Thank you for agreeing to judge a mock trial competition for the Iowa State Bar Association. We really appreciate the time that you put into judging, and we hope that this briefing is helpful for you. The first thing you have to know is how many kids we're dealing with. So each team is made up of 8 to 10 students. You're going to see 4 attorneys, 3 witnesses, 1 timer, and then sometimes 1 to 3 alternates for each side of the case. So a total of 16 to 20 students. Each attorney is going to perform 2 separate roles. The same attorney cannot deliver both the opening statement and the closing statement. And if you are judging high school, it's also important to know that attorneys cannot do 2 directs or 2 crosses. Each room is going to have 2 to 3 judges. If you are lucky enough to be in that 3-judge trial, you're going to have a presiding judge, and then you're going to have 2 scoring judges. In a 2-judge trial, you're going to have someone who does double duty. They preside and score, and then you're going to have a scoring judge. Duties of the presiding judge: they're going to conduct a pretrial conference. They're going to rule on objections, and by doing those things, keep the trial moving. They are also going to handle any rule violations that may pop up. It's also important to note that there are no motions allowed in mock trials. So if you happen to get somebody who's really eager and makes a motion for directed verdict or something like that, your ruling is quite easy. It's denied. During the pretrial conference, the students are going to make their team introductions. If we are having a live in-person trial, they're going to hand you your judging ballots and a trial notebook. If we are having a Zoom trial, then you won't receive those things from the students. You'll have access to everything you need via links that John Wheeler will provide to you. The students will likely want to discuss stipulations. They may also want to tell you what exhibits they're planning to use. It's also a very good idea to go over enlargements and demonstratives and make sure there are no rule-based objections. So I'm not talking about rules of evidence here, whether they're admissible or not. I'm talking about the rules of procedure. So whether there is some sort of rule violation for that enlargement or demonstrative. It's also a good idea to go over swearing in the witness. My personal preference is just to assume everyone is sworn, so we don't have to remember to swear every student in. If you like swearing them in, you are certainly welcome to do that. It's also important to go over permission to use the well. The students are likely going to ask about that. We are a standing jurisdiction, so when we're having a live and in-person round, it's very important to give them that permission to use the well, because how they handle themselves and how they present in the well is a big part of how student attorneys are judged in mock trial. In our new and unknown Zoom world, hopefully the students will have worked out their technology and their camera placement to the point where they can stand and be in a well of some sort. Some of the teams are having to have each student on their own Zoom window, so they may be standing in a room by themselves. Some are trying to set up a courtroom and have one wide angle. To the extent possible, if a student can stand to present and they're doing an attorney role, that is the preference. If the student's situation on their room is clearly such where that's going to be difficult, maybe need to have some flexibility, but the preference is always going to be to have them up and on their feet as much as possible. It's also good to go over the rebuttal closing argument. Rebuttal does have to be reserved by the plaintiff or the prosecution. They can either do that during pretrial, or they can do it when they start or finish their actual closing argument. Videotaping and photography is another important point to hit. The default rule in mock trial is that if one of the teams says no to the videotaping and photography, that is the end of it. There's no fighting about whether it's more important for my grandma to see it. That doesn't happen. In the new Zoom world, John is having to deal with the fact that we want people to be able to see what these kids have done. So we may be allowing coaches to do some recording. If there is anything specific you need to know about that, we will make sure that you get that information. It's also a good idea to remind everyone just to turn their cell phones off. Objections in a mock trial are untimed. So the students have time limitations on how much or how long their presentations can be for open, directs, crosses, and close. The objections do not count toward that time. It's important to note that in an opening statement or closing argument, a student cannot object to the other side's presentation. However, the student who handled that open or close can stand up after their opponent is done and say, Your Honor, if I had been allowed to make objections by the rules, this is what I would have objected to. You're not going to rule on those objections, but you can certainly take them into consideration in scoring if you think they're good or they're bad or they're ugly. Objections during examinations may only be made by the attorney on the opposing team that directs or crosses the witness being examined. Conferences with co-counsel do go against the team's time. That's Rule 5 in the procedures. So if you have a student who gets stuck and says, Your Honor, can I consult with co-counsel? Go ahead and let them have that opportunity, but the stopwatches that the timers are holding should start running. That should count against that student's examination time. Personally, to try and keep the case running, I usually tell them briefly, and if they get stuck and they're standing there for 30 seconds arguing, I'm like, counsel, we need a response. It's really easy for them to lose track of how much time they're burning on that, and it can really drag the case down. Students, generally we want to keep the objection battles to one response per attorney. So an objection, the response, and then a rebuttal. Particularly with the younger students, they may not, in middle school, they may not have the ability to go far beyond that. Our older middle school students, and certainly many of our sophisticated high school students, could stand there and argue with you for an hour about the details of a hearsay exception, but we don't have an hour to do that. So do keep in mind the need to keep the case moving and try as much as possible, even though it can be fascinating to let them argue, to keep those objections to an objection, a response, and a rebuttal. The Iowa mock trial rules of evidence versus the Iowa rules of evidence, the students have fewer hearsay exceptions. The one I like to point out is public records. They do not have a public records exception. So if there is an exception that's in your head and you're wondering, why didn't they bring this one out? Please feel free to go check the mock trial rules of evidence. You'll have access to those during the trial and just see. It may be one that they don't have available. The authenticity rules are also redacted. We just assume that documents are what they purport to be. The students also have additional rule numbers in the 1100s, and they formalize things that are traditional trial objections like speculation, and also include that additional rule there called unfair extrapolation. That rule is found at 1107 in the students' mock trial rules of evidence, and the purpose is to prevent teams from inventing material facts on their direct examination. So a material fact is one that affects the outcome of trial. So if the students are making up background things like the character's favorite color or, you know, what they were doing the day before and it doesn't really affect anything, that's what we would call a reasonable inference, and they're allowed to make a reasonable inference based on the witness's affidavit if it doesn't affect the outcome of the trial. So if there's a gray area and there's some wiggle in the jiggle, they can make that reasonable inference, and as long as it's reasonable, they're good to go. If they're just wholesale making up facts that wildly change the outcome of this case, that's a violation of this rule, and it's a serious problem. There are two ways to handle it. You can reserve ruling and request an impeachment on cross-examination. That is my personal preference in most situations. Impeachment is a skill that these students learn, and even at the middle school level, the sophisticated students are able to do that and able to do that properly, and I want to give them the opportunity to demonstrate that skill. You can also hold a bench conference. Now, I will say that in most situations, students who know how to do an impeachment are not going to object to unfair extrapolation. They're just going to note it down and they're going to do the impeachment on their cross. So if you do have students that object to unfair extrapolation, you do have the ability to simply hold a bench conference to let each of the two attorneys handling that examination give their version of events on where they think in the affidavit there's support for this, or if there is no support. And then you can make a ruling, or you can just say, you know, the court will take that into consideration. For me, I'm most likely to do something like that if the students are clearly very new to mock trial and they're struggling with a lot of the basics. That's an indication to me they probably don't know how to do an impeachment, and they're taking the best option they can to bring a real issue to your attention. I would also say that my personal preference would be to simply reserve ruling and tell them that, you know, the court will take notice of the issue. And that way, you know, if you make a ruling on it and your co-judge doesn't necessarily agree with your ruling, it's a little bit less confusing for the kids if it's just kind of left to each of us are going to make our own decision instead of you making a decision and then them thinking your co-judge is wrong. So that's just a little bit of guidance on how to handle that. Now, every trial is going to consist of a pretrial conference, the opening statements by both teams. It's important to note that the defense is not permitted to reserve its opening statement. They have to present their open directly after the plaintiff's open. You're then going to have the 3 plaintiff or prosecution witnesses directed and crossed. If time allows, you can take a short break. During that break, the students are only allowed to speak to their own team. They're not allowed to speak to their coaches, to their parents. Usually when we see a suspected violation of this rule, what has happened is an overeager grandparent has come up and, oh, honey, you're doing so well, and let me give you a hug. The kids get very hung up sometimes on seeing a competitor talking to a friend or a family member. We don't quite know how policing this will shake out in the Zoom world. It's a brand new world for all of us, but that is the rule, that they're not allowed to consult with coaches or parents or anyone outside of their team. That would include, team members from another team from their school. Then you're going to have the defense case in chief and the cross-examinations of those witnesses, another short break if time allows, and then you're going to have closing arguments by both teams. And just a reminder that the plaintiff or prosecution does have to reserve their rebuttal time. Another note on the reservation of rebuttal time, every now and then, particularly with younger kiddos, they just forget. They don't handle it in pretrial. They forget when they start their exam. They get up to do their rebuttal and they haven't reserved their time. One thought of how you can handle that, this is how I personally handle it, is that I will ask the defense if they're willing to waive the requirement for reserving that time, and if they waive the requirement, allow the rebuttal. And oftentimes I will bump the defense on their team score for showing that, that collegiality. If the defense says no, then I'll enforce the rule. Now, you don't have to. You could say, you know what, I'm still going to let them do it. I think it's an honest mistake, and that's totally fine. That's up to that presiding judge. Personally, I will enforce the rule if defense says they're not waiving it, but I'm not going to give them any bump on collegiality for that. All of the parts of the trial are timed, as we discussed. You don't have to know what the time limits are. The student timers should be on top of that and be taking care of that. If time does expire, the timers should let you know. They should clearly and audibly tell you time has expired. You have the right to allow the student up to 45 seconds to finish that part. Now, the thing you need to know is, number one, you're not required to allow that extra time, and number two, 45 seconds is a huge amount of time in mock trial. For an open, they get, I think it's 4 minutes, and so if you give them 45 seconds, that's almost 20 or 25% more time almost. It's a lot of time if you think about it. So use your best judgment. Think about things like whether the other team has intentionally run the clock on cross-examination by talking no matter what, cross techniques are used. Is the attorney just disorganized? Have there been a lot of conferences with co-counsel? Think about those kind of things and use your judgment on how much to give them. Good compromises are often letting the student finish their thought. If it's a statement or an argument, let them finish one question and get the answer in, something like that. So for me, if I think a witness on cross-examination or a whole slate of witnesses have been wildly unreasonable and just intentionally running the clock, I'm going to be inclined to give that crossing attorney some more time. If I think that attorney is just disorganized and the team hasn't planned their case well, I'm probably going to let them finish their thought and call it good. It's really up to you what you want to do as the presiding judge up to that 45-second rule. For scoring, each separate attorney and witness role is going to receive a score from 1 to 10. 1 is the worst score and 10 is the best score. There is also a team score, which is a separate score at the end. It's not an average in any way. It is a score from 1 to 10 on how the team did overall. So things like organization, collegiality, how they addressed you as the bar, how they dealt with, rolling with the punches, that kind of thing. Each team can earn up to 150 points during the round. When you're scoring, half points are fine. Please do not go smaller than half points. If you're doing a Zoom round, the electronic ballot we're using actually will not let you go under a half point, is my understanding. So we're making that part a little bit easier for you to keep in mind. Please do score as you go. This may be a little tricky if you're doing a Zoom round and you only have one computer screen. If you need to keep track on a piece of paper, whatever you need to do, If you try and record all your scores at the end of the round, it's going to run together, it's going to blend together. These rounds are about 2 to 2.5 hours long. Closer to 2 on the middle school side, closer to 2.5 on the high school side. And if you wait until the end, those 6 witnesses are just going to blend together. The suggestion that John Wheeler and I often make is that if you are concerned about your scoring, at least put down a provisional score as you're going along, and then you can always go back and change that. One of the nice things about these new electronic ballots is the students won't see where you scribbled or scratched out a previous score. They're just going to see the final score. So this is a sample of our old paper ballot. We're not going to run through this in depth because this briefing is primarily going to be used for Zoom rounds, because we do in-person briefings for in-person rounds as much as possible. It does have space for score, for the name of the student, which the students will fill out, and then it also has a space for comments. For the online Zoom rounds, we're going to have 2 separate ballots, one that just has the numbers and one that has the comments. There will be a separate video uploaded to help step you through how to use those if you need that assistance. The important thing to know is we need that number ballot back as soon as you can after the round ends. If it takes you a little while to submit the comment ballot, that's totally fine. We love having your comments. We want your comments. The kids go crazy over getting your comments. But the number ballot is the one that has to make it in first. And this is just an example of how you would fill out the old school paper ballot that hopefully we'll all be able to get back to using soon. When you're scoring opening statements, keep in mind that opening statements are about telling a story. You know, it's story time at the library. It's not an argument. It's not a list of elements. So the primary characteristics of a good open are going to be that the student tells the story and introduces the characters, that they include a brief recitation of the law and the burden, and that they present it persuasively, particularly if they can present it without notes. We do have a scoring rubric. It will be available to you on the website with the ballot and other links. That rubric goes into a little bit more depth, but if you keep in mind that a high scoring open is going to be a student on their feet in the well, no notes, telling a story, and by the end of that story, you know what happened, you know the theory of the case, and you've got a theme in your head that's going to click around all night and everything's going to fit with it. When you're doing scoring of examinations for those attorneys who are handling the direct and the cross, the primary scoring criteria to think about are the form of questions. Are they doing open on direct and closed on cross? Is there a flow and logic to their examination? How much are they using their notes? The preference in mock trial is that they use few or no notes unless they're clearly reacting to something that happened in direct or cross or redirect, right? I wrote down this thing you said on my sticky and I found it really interesting, kind of thing. We want to see confidence and we want to see a good presentation. We want to see them using the well. When they're in the well, are they able to stand still? Are they able to be non-distracting with how they stand? Are they using demonstratives or enlargements properly? Are they following all of their procedures properly? Those kind of things. And again, the scoring rubric can give you some more specific guidance. When you're scoring a witness, we look for whether they know their stuff. Do they know their affidavit? Do they know their facts? Are they telling you a story? And are they playing the character in an interesting and believable manner? You know, a ham for a non-ham character is to me just as bad as someone who sits there and just kind of mumbles what they're doing. We want them to play a character in a way that's believable and makes you think that character is really there in front of you, not this like 7th grade middle school student. We also want to see if they can maintain their character on cross, or do they just abandon their character and start fighting for their side? Do they keep character when they're sitting in the back of the courtroom? That's another important one. Please also note that use of notes by a witness is actually a rule violation. So if you see a student using notes, that is a situation where there should be an extremely low score. They don't completely give up their score. It's not a 0 score situation, but it is a significant and serious rule violation. For closing arguments, we want these students to be able to accurately discuss the law at issue in this case. We want them to apply the facts to that law, and we want them to be persuasive when they do it. We also want to see if they're confident, if they're using that well, if there were key demonstratives in this case or key pieces of evidence, do they bring those back out and discuss them? Is their argument logical? Does it follow a good flow? Can you understand what's going on? Again, we want to see limited use of notes, and any note usage should be something that's just helping them remember what happened in this trial rather than reading a script or having an outline that they're going through. Team score. The team score should be based on teamwork, professionalism and integrity, their overall performance as a group, any rule violations. If a rule violation is brought to your attention, you can hold a conference with both sides to find out from a student representative what happened. Coaches cannot be involved in those conferences. If you believe something is too serious to handle in the courtroom or with point adjustments on the ballot, you can bring that to John's attention during a break or after the trial. He's going to make sure that everyone has his contact information so you know how to get a hold of him during your Zoom trials. The other thing I would bring up for team score that is particular to the middle school 2020 tournament, the case that is being used this year was adapted for the students from a high school case, and it has a number of potential counts and it has a number of potential affirmative defenses. Some of the teens have been very concerned about what happens if they don't address all of them. What they've essentially been instructed is that the judging is going to focus on whether they're giving a comprehensive and cohesive presentation. So if you're very familiar with this case and you're wondering why the heck didn't they pick that affirmative defense, we're trying as much as possible to steer away from scoring them on which ones they presented and instead score on cohesiveness of their presentation. You know, are they clear about what they're doing? Are they clear about which counts? Are they clear about which defenses? And is their presentation cohesive to the choices that they have made? Just because this is a rather complicated case from a legal standpoint for middle schoolers. One of the things that is often key for these students and is going to be available on the electronic ballots is nominating outstanding attorneys and witnesses. You can nominate up to 3 attorneys and up to 3 witnesses. Please do use the student's actual name on those. If you need to, because with Zoom trials, it's going to be hard to see name tags and that kind of thing. Don't be afraid to just have them go around the room and have everyone say their name to kind of refresh you on who might be who if it's hard to tell from your ballot. Please also circle the side of the case. If you don't want to nominate, I believe the electronic ballots are going to have a spot where you can designate that as well, just like you would for the paper ballots. Please be aware that listing them in order is important. We want who you think the best student was at the top and then go down through the 3 because the sequence really matters for all regional and all state honors for these kiddos. Please do consider nominating them. You certainly do not have to. There are certainly rounds where it's like, yeah, none of these guys are super special. I shouldn't say it that way, but it really means a lot to the kids to see their name on that ballot. So personally, I tend to nominate in every round I'm in because those kids did the best in their round. And for a team that's unlikely to take a trophy home, that can be really affirming for a student to see their name on here. But if you didn't see anything you thought was worthy of calling out, you don't have to list anyone. If you only saw 1 performance or 2 performances that were worth nominating, list those 1 or 2. It's totally up to you, and this is a decision for each judge. So don't confer with your co-judge, just nominate based on what you saw in that round. At the end of the trial, there's going to be an oral critique. Please make sure that you get your number ballots into John, the ballots that actually have the scores on them, so that he can start tab, and those ballots need to be turned in before you start giving your oral critique, just so we can avoid any claims that what one judge said to the other influenced their score and they changed it or something like that. Please do try and keep your comments big picture. Keep the comments positive overall. We love constructive criticism. It's very useful, but being just negative is not, particularly with the middle schoolers when they're just kind of getting up on their feet and trying this. So to the extent that you can find positive things to call out, that's fantastic. Try and keep your comments about the overall round or about things you saw overall. Sometimes it is really nice if a student did something phenomenally well, you know, it's nice to call that out sometimes. But the more we can keep those comments big picture, the better it is. Please try as much as possible to keep your comments to about 5 minutes per judge, especially because we are running some evening rounds tonight and we have middle schoolers. So we're starting around at 6 p.m. Middle schoolers may have bedtimes of 8 or 9 p.m. Round is running until 8. They need to get home, all that kind of thing. So please do give your comments. The kids love your comments, but try and keep them to that 5 minute per judge. Some additional differences to make sure you're aware of from, the real world. Students are not permitted to talk to coaches or any other family until the round is over, including breaks. Sequestration of witnesses is not allowed in middle school and high school mock trial in Iowa. Cross-exam is open scope. So the first cross that any student attorney has is a completely open scope, but redirect and recross are going to be that closed scope like we're used to. Each student attorney is limited to one redirect or one recross per witness. So you can have a direct, a cross, a redirect, a recross, they're done. Doesn't matter if they think they have more to say, they are done. That's in the rules. And again, like I've talked about before, we are a standing jurisdiction. That is a significant part of what the students are trained on and what is in the rubric for them. So to the extent that in our new Zoom world, the students can still be in a standing jurisdiction, we would appreciate it if you could keep that moving with them. And finally, again, thank you so much for volunteering to judge. This program is not possible without the support of volunteers like you. We're all on a little bit of a wild ride right now with the pandemic and figuring out how to still make this tournament a reality for the students. And we appreciate your patience with us, and we appreciate you volunteering to judge. We cannot thank you enough for taking time out of your day to enrich the students' experience. And that is the end of our briefing. I hope it was useful for you. If you have any questions following this briefing, you can email me. My email is christinat@watsonpc.com, and I'll go ahead and spell that. So it is CHRISTINAT@Watson, WATSON.com. You can also always contact John Wheeler with any questions that you may have. So thank you again, and I hope you have a great morning or afternoon or evening or weekend whenever you're watching this. Thanks.